Hello, everyone. Welcome to part 7 of the SDV COVID-19 webinar series. Today's topic is the next wave, general liability coverage for COVID claims. My name is Jeffrey Vita, founding partner of the firm, and I'm happy to be with you today. I call it the next wave because right after the pandemic, many of our clients were calling to find out whether there was potential business interruption coverage for their lost business and interruption of business. So that was clearly the first wave. That was the first thing that we were asked to do. And in looking at those policies, those are first party policies. And you probably have seen our prior webinar series on that topic. I'm a firm believer that as businesses resume operations, and now that we're into phase 2 of the following the pandemic, many people are returning to work, many businesses are resuming, and I think the next wave of claims will be suits by third parties who have contracted the virus after returning to their normal business environment, whether it be a work site, a premises, a retail shop, whatever it may be. Should they be exposed and contract the virus, they will be looking to bring a claim against those responsible or those who were in control of the premises where they believe they were infected. So those are the liability claims that I think will be coming soon. And this webinar series today is devoted to talking about what should you do if you are subject of one of those claims, a third-party claim against you, and where do you turn? So the first place you turn would be your general liability coverage. And general liability coverage has a Part A and a Part B. We're going to talk about both, but let's start basics with Part A, which is in order to trigger a Part A of your general liability policy, you need either bodily injury or property damage. And the first thing that comes to mind is bodily injury, obviously, for those exposed to the virus. Bodily injury is simply defined in the normal GL policy as sickness or disease. So clearly, COVID-19 falls within that definition under the GL policy. The more interesting issue could be whether COVID-19 meets the definition of property damage in a GL policy. And I'll just give a quick example or two, but property damage is defined as physical injury to tangible property under your GL policy. But there's also a second component to the property damage definition in your GL policy, which is loss of use of tangible property that is not physically injured. So the question becomes, can you have a GL property damage claim for COVID? So the example would be where you have exposure on your premises or at your project site, causing the site to be shut down, and you sustain a loss of use of tangible property that isn't physically injured. So that could be a situation where you might actually have a property damage claim under your general liability policy. Still in the coverage A section, let's next talk about whether the bodily injury or property damage at issue was caused by an occurrence. Because all GL policies, you need either bodily injury or property damage caused by an occurrence during the policy period. Those are the prerequisites to satisfy the insuring agreement under a GL policy. So the question would be, well, was the bodily injury or the property damage caused by an occurrence? An occurrence in a GL policy is simply defined as an accident. Accident is not further defined in the GL policy. So for example, a claim might be that a claim against you, a third-party claim against you, that you were negligent in the operation, management, supervision of the site or the premises, that you failed to exercise reasonable care in guarding against, warning of, or reasonably discovering the risk of exposure to COVID-19 at the premises. Or another example might be where you are hired to do some HVAC work, for example, and due to some poor workmanship, it results in inadequate filtering of the air in the premises, which causes an increase in those cases within the building. All of those could be considered occurrences. And again, the definition of occurrence in the policy simply requires an accident. So all of those examples that I just gave should constitute an accident under a GL policy. The other thing that you do need to trigger a GL policy, keep in mind, is you need a suit. So you need an actual suit, a lawsuit against you. So simply a demand letter against you by a third party claiming that they were infected at your premises may not be sufficient. There are situations where a demand letter, if it is sufficiently adversarial and asks for specific damages, does constitute a suit. But keep in mind, you generally need a suit to trigger GL coverage. The other thing I want to throw out there is also keep in mind under your GL policy, when you read the insuring agreement, it insures you for damages that you're legally obligated to pay because of bodily injury or property damage. And there may be arguments that you incur damages as a result of exposures on site or at your premises. And those expenses that you incur because of that exposure may in fact meet or satisfy the insuring agreement under your GL policy. I also want to mention, we've been talking about coverage A of the general liability policy, which is bodily injury or property damage. There's also a coverage B under your GL policy, which is personal and advertising injury. And that may not naturally come to mind as we talk about the COVID-19 scenario. Keep in mind the following though, as we thought more about this, we have seen claims that cruise ships were forced to dock for lengthy periods of time, because a handful, 1 or 2 or 3 passengers were exposed and the entire cruise ship was forced to quarantine and no one could get off the ship for a significant period of time. Part B under your GL policy covers things like detention or false imprisonment, things like that. So you could see claims by passengers who were not who were not positive for the coronavirus, who felt that they were imprisoned on the cruise ship once it docked for a significant period of time. So in a scenario like that, you could see a Part B GL claim happening. Also, Part B also covers oral or written publication of material that violates a person's rights of privacy. So for example, if you disclose the identity of someone who tested positive for COVID-19, that disclosure may prompt coverage under your coverage B of your GL policy. So those are a couple specific examples that you might want to keep in mind as these third-party claims ramp up in this pandemic scenario. Still in the main section of your general liability policy, we always have to talk about notice. And notice under GL policy generally requires that the insured give notice as soon as practicable of the occurrence. So keep in mind that if you do receive a demand letter or somebody does claim that they were infected on your site, that you should notify your GL carrier as well as other insurers, but certainly notify your GL carrier. Don't wait to do that. Also keep in mind that sometimes your notice provision in your GL policy is endorsed or amended to indicate, if you're an organization, for example, it may be amended to indicate that you do not have an obligation to provide notice until someone at an executive level or someone in the risk management department is aware of that. So that may give you some additional time to provide prompt notice to your insurer. The next thing I want to talk about, assuming that we satisfy all of those conditions of the insuring agreement, is the exclusions. And the exclusion, there are several exclusions that we're going to talk about that are very common in your general liability policy. Keep in mind that the burden of proof on exclusions is on the insurer. So unlike the things that we've been talking about, which is an occurrence, bodily injury, property damage within the policy period, the burden of those establishing those items is on the insured. when you shift to looking at exclusions within the policy, the burden of establishing that a particular exclusion applies is on the insurer. So the insured can sit back and force the carrier to prove that a particular exclusion applies. The first exclusion that has been discussed in this environment is the bacteria or fungi exclusion. And I do have an endorsement number. It's CG, or form number rather. It's CG 2167-1204. And the bacteria or fungi exclusion, that particular form number does not reference viruses or pathogens or microorganisms or communicable diseases. It merely references fungi or bacteria. And I think there's a decent amount of information within the scientific community that bacteria and fungi are not viruses. They are distinct, they're different. So if you have a bacteria or fungi exclusion on your GL policy, that should not be an exclusion that you need to worry about for COVID-19 exposures. The next exclusion that is potentially applicable and that comes to immediate mind is the pollution exclusion. And a typical pollution exclusion on a GL policy excludes bodily injury or property damage arising out of things like the discharge, dispersal, seepage, migration of pollutants. And when you hear those terms, those verbs, discharge, dispersal, seepage, migration, it does not seem like it applies to a virus setting. The word pollutants typically is defined in your pollution exclusion, and pollutants is generally defined as a solid, a liquid, a gas, or a contaminant. But the word contaminant is not further defined. So the question becomes, is COVID-19, is that virus, does it meet the definition of a contaminant within the meaning of a pollution exclusion? And here is where, keep in mind that choice of law in insurance coverage matters. And this is a prime example of where choice of law can make all the difference. And I'll give you an example. States like California, New York, New Jersey, the term pollutant has been interpreted by many courts, and the courts narrowly interpret it, and they limit it to traditional environmental pollutants. So in that scenario, COVID-19, the virus, should not meet that definition. There's a case in New York, Belt Painting versus TIG, case out of California, McKinnon versus Truck Insurance Exchange. Those cases confirm that the pollution exclusion was intended to apply to traditional environmental pollutants. And it does not seem like COVID-19 would fall within that interpretation. On the other hand, states like Illinois and Connecticut, it's unclear whether pollutants are limited to traditional environmental pollutants. The case law is mixed and simply is not definitive on that topic. Florida and Texas, on the other hand, have interpreted pollutant to include substances that are not considered traditional environmental pollutants. So Florida and Texas would be more likely to interpret the pollution exclusion to apply to a COVID-19 scenario. And I can go one step further. Florida does have existing case law that a virus is a pollutant and therefore excluded under your GL. In that case is First Specialty Insurance Corporation versus GRS Management. Texas has not determined if virus is a pollutant, but it has, as I said, already determined that a variety of substances outside of traditional environmental pollutants do constitute pollutants. So choice of law matters. I gave you an example of some of the jurisdictions that have dealt with that. Depending upon the jurisdiction that you're in, could significantly impact whether a pollution exclusion on your GL policy would apply to a COVID-19 scenario. Another exclusion that we are seeing on general liability policies is the communicable disease exclusion. And I'll give you a couple examples. I've seen a few different ones so far. But the communicable disease exclusion has generally not been that common prior to COVID-19. It's been around, but it's just not that often that we see it. Since COVID-19, however, we have seen all of a sudden that communicable disease exclusion pop up with more frequency. So there are different versions in the industry of the communicable disease exclusion. And there is an ISO version, and that is ISO version CG 21320509. And it simply says that this insurance does not apply to bodily injury or property damage arising out of the actual or alleged transmission of a communicable disease. And in the ISO version of the communicable disease exclusion, the phrase communicable disease is not further defined. However, the exclusion is fairly broad in that it applies to different scenarios which allege negligence or wrongdoing in supervising, hiring, employing, training, monitoring of others that may be infected with and spread a communicable disease. It applies to testing for a communicable disease, the failure to prevent the spread of the disease, and the failure to report the disease to appropriate authorities. So all of those fact patterns are governed or covered by the ISO standard communicable disease. So even though the word virus isn't present, it is possible that COVID-19, and probably I would say likely, that a court would find that COVID-19 is a communicable disease. Keep in mind, though, there are separate exclusions for viruses. So you could make the argument that if the carrier is merely using a communicable disease exclusion and has a virus exclusion, but it's not on your policy, that they meant to not include viruses in that. Still talking about communicable disease, I gave you the example of the ISO standard communicable disease. There are manuscript forms out there, and you need to be on the lookout for those and be wary of the language, because obviously in manuscript endorsements, the language varies by carrier. So one of the manuscript endorsements that talks about communicable disease does contain a definition of communicable disease. And it's defined as any infectious disease transmittable by direct contact with an affected individual or the individual's discharges. And clearly, I think a carrier would argue that COVID-19, the virus, fits within that definition. This particular manuscript exclusion that I'm referring to, it does have a laundry list of things that it also covers, and which is very lengthy. And within that laundry list, this particular insurer has the word coronavirus, parenthesis, including COVID-19. So it is crystal clear in that exclusion that the coronavirus is included as within the communicable disease exclusion. And as I said, there are virus exclusions out there. So we've talked about so far the bacteria or fungi exclusion, the pollution exclusion, the communicable disease, and there are virus exclusions that are out there. They're not common. They show up from time to time, and generally the virus exclusion started showing up in and around 2006 after the SARS epidemic, avian flu and things like that. Virus exclusions became fairly common in the first party context. We are now seeing those virus exclusions migrate into the general liability context. They are, as I said, they're not that common, but if you do have a virus exclusion, it would be very difficult to circumvent that, since clearly COVID-19 is in fact a virus. I will note there's another exclusion that comes to mind when you look at the GL form, and that is the expected or intended injury exclusion. Basically, and that exclusion applies to bodily injury or property damage expected or intended from the standpoint of the insured. So you could have a crazy situation where the owner of a premises or someone in control of the premises knows that there are people infected with COVID-19 on the at the place of business, and nevertheless they allow customers into that business, or for example, they know that there are employees who are affected who are still working, and nevertheless they allow people to onto that premises. You might have a situation where the carrier would say, well, the expected or intended injury exclusion should apply because it was known that the virus was on site and that particular owner did not take any precautions. So I will say in that situation, generally for the exclusion to apply, the insured would have to expect or intend the injury, not just be negligent in allowing people onto their premises. But you could see a scenario where in that factual setting, a carrier would raise that exclusion. So those are some of the more common exclusions that you will see pop up as we debate whether there is general liability for these COVID claims. I do want to take a minute or two to mention excess coverage, excess GL coverage, because again, very important. Does the excess policy follow form? If it does follow form, it will typically incorporate those exclusions or those definitions in the underlying policy. So if it's a true follow form and the underlying policy has a virus exclusion, then similarly, it would be contained within the excess policy. However, if your excess policy is not a true follow form, and many are not, it is arguable that if the excess policy has its own set of exclusions and there is no communicable disease exclusion or there is no virus exclusion, even though the underlying policy has such an exclusion, then you have a very strong argument that the excess policy does not follow form, and since it doesn't have an applicable exclusion, that there is coverage under that. So looking at that, whether it follows form or not, could be very important in determining whether excess coverage is in fact available. Also, sometimes in excess GL policies, we find a coverage called crisis management coverage. And crisis management coverage pays for costs associated with crisis management, securing the site, providing medical services to those who are affected, and as well as consulting costs for any PR firms that are brought in to deal with the pandemic. So look at your GL excess to see if it contains such crisis management coverage, because there may be some limited coverage in that component of coverage that could be beneficial to you. Under an excess policy, it usually requires immediate notice, so you need to be careful of that and notify your excess carrier. If you know your underlying policy has a virus exclusion, but the excess does not, and you believe the excess coverage should drop down and provide defense and indemnity for you, you should immediately notify your excess carrier. And also, if you did retain a PR firm to deal with the fallout from having COVID-19 on your premises, the crisis management coverage may be a source for recouping some of those expenses. I also want to make a quick mention of an indemnity obligation and whether or not there may be potential coverage under your GL policy. So generally, forget COVID for the moment, but generally, if you undertake an indemnity obligation to another, there may be GL coverage for that under the exception to the contractual liability exclusion, if the contract with that other party meets the definition of what is referred to as an insured contract under the GL policy. So you need to refer to the definitional section of the GL policy, which talks about various settings in which insured contracts are common. But if you agree to undertake the indemnity of another contractually, that generally is an exception to the contractual liability exclusion, which means So assuming your contract meets the definition of insured contract, your indemnity obligation to another is insured. So that analysis should be no different in the COVID-19 scenario. So as companies return to work, or as businesses return to the project site, for example, we have seen where some entities or some individuals have asked to be indemnified for any COVID-19 claims. So for example, you bring in a company to do some consulting on site, or you bring in a remediation firm to remove any contaminants on site. Those consultants or those companies brought in may ask you to indemnify them for any subsequent COVID-19 claim. So if you do agree to extend indemnity to another, you want to look at your potential GL coverage if that party then pursues you contractually for your indemnity obligation. The other thing to keep in mind is we have seen, this is clearly in the construction context, but we have seen endorsements from time to time that are very broadly worded, and they may say something like exclusion injury to workers endorsement, which says under your general liability coverage, the coverage does not apply to any claim arising from bodily injury to any contractor or subcontractor hired or retained by any insured, or any person who is an employee, temporary worker, or voluntary worker who was hired or retained by any insured. Be very careful of those injury to worker endorsements, because in that construction setting, if you agreed to indemnify someone and they bring a claim against you for that indemnity, and you are seeking coverage for your indemnity obligation under the analysis that I just mentioned, which is the insured contract exception to the contractual liability exclusion, if you have one of those exclusions on your program, injury to worker endorsement, that will potentially negate coverage, and you will not be insured under the general liability policy for your indemnity obligation. Very important point, so keep on the lookout for that and make sure that your program does not have such an exclusion. Also, when we think about GL, I immediately want to talk about additional insured coverage. So keep in mind, if you are sued and for a COVID-19 general liability claim, and you believe someone owes you indemnity, or someone else is responsible for that, or another party named you as an additional insured on their policy, you want to look at potential additional insured coverage for that claim against you. And we could have a whole section on webinar series on AI endorsements, but the common one out there right now is the 2004 version, which requires that your liability be caused in whole or in part by the named insured's acts or omissions, or those acting on their behalf. Under that standard, if you believe that your liability for this potential COVID-19 claim derives from another's acts or omissions, that another party was supposed to clean up a section of the premises and they didn't do a good job, somebody contracted a virus and brings a claim against you, the owner or the GC on the job, you may have additional insured coverage from that downstream party that promised to provide insurance for you. So that is clearly something that you'd want to look at so that you don't utilize your own insurance program for that claim. And keep in mind, when you are reviewing any additional insured endorsements, you want to reject any additional insured endorsements that have virus or communicable disease exclusions on them if you can. Certainly in this setting, with having such an exclusion may negate that AI coverage. So if you can remove those or have that in your contract that there should be no such virus exclusion on the program, that would be certainly helpful. And the final thing that I'll note is, taking proper precautions and following all the safety protocol to avoid the claim in the first place. Because if you don't have liability for something and you don't get sued, you don't need coverage. So avoiding the whole situation in the first place is the best course of action. And the way to do that is follow the protocol, keep your premises and your work site safe. As people return to work, follow all the CDC protocol in terms of temperatures, social distancing, and frequent hand washing and sanitizing stations, and all of those things that prevent the liability in the first place. So long as you're following those, you put yourself in a better position to avoid the claim in the first place. So that is it for potential general liability coverage for COVID-19 claims. It's been a pleasure to be with you today. I want you to look out for our next part 8 of the SDV COVID-19 webinar series, which should be out in a week or two. If you'd like to contact me to discuss any of the issues that we've talked about today, please, at the end of this webinar, you will see my contact information, and please feel free to reach out at any time. Again, pleasure to be here, and I hope to talk with you soon, and please stay well and stay safe. Take care.